whistleblowing and whistleblowers. Consideration should also be given to a transversal code of conduct for all employees of the state. 8.10, the President to ensure that the Executive Ethics Code is updated in line with the review of the Executive Members' Ethics Act. 8.11, the Public Protector, in terms of Section 64C(1) of the Public Protectors Act, brings to the notice of the National Prosecuting Authority and the DPCI those matters identified in this report where it appears crimes have been committed. Close quotation. The remedial action taken by the Public Protector as set out in 8.5, 8.6, and 8.8 are all dependent on remedial action 8.4. If 8.4 falls away, the rest follow. However, it would seem to me that the remedial action taken in 8.9, 8.10, and 8.11 have nothing to do with the appointment of the Commission of Inquiry. They are independent remedial actions to be dealt with by different institutions. It is therefore not surprising that the applicant in the first application is seeking primarily an order directing the President to comply with remedial action 8.4. Prayers 2 and 3 of the applicant's notice of motion are inseparable and represent the main order that applicant seeks. In the conditional count application, the President seeks a stay of the implementation of the remedial action as set out in 8.4 of the report. The issues. The crisp and sharp points of dispute between the parties are the following. 1. Whether the President's application in case number 91139/16 to review the Public Protector's remedial action has the automatic effect of staying implementation of the remedial action. 2. In the event that this court finds that the review application does not have the effect of automatically putting on hold or suspending implementation of the remedial action, whether the President is entitled to the relief in the conditional count application for a stay of the implementation of the remedial action pending the outcome of the review application. At the center of the dispute in the review application are the constitutional powers and obligations of the President vis-à-vis the Constitutional Court's finding in the matter of economic freedom fighters versus Speaker of the National Assembly and others, 2017 in Volume 3, 580 Constitutional Court. In short, the applicants argue that that decision, referred to as the famously now referred to as the Nkandla decision, concluded that remedial actions by the Public Protector are binding and should be implemented. The applicant also relied to a large extent on the decision of the Constitutional Court in the matter of Tshwane City versus AfriForum and another, 2016 SA 279, also a Constitutional Court matter. In his contention that an application for review does not result in the automatic suspension of the remedial action, the applicant says that what is required is an interdict or a stay application. It is not surprising that prayer 2 in the applicant's notice of motion is worded in precisely the same terminology as the order granted by the Constitutional Court in the Nkandla decision, which reads as follows, I quote, "The remedial action taken by the Public Protector against President Jacob Zuma in terms of Section 181(2)(c) of the Constitution is binding." Close quotation. Prayer 4 of the application also mirrors the wording in the order of the Nkandla decision, which reads as follows, I quote, "The failure by the President to comply with the remedial action taken against him by the Public Protector in a report of 19 March 2014 is inconsistent with Section 83B of the Constitution, read with Section 181(3) and 182(1)(c) of the Constitution as invalid." Close quotation. Before I deal with the issues before me, I deem it appropriate to refer to a paragraph in the Nkandla decision at page 609, being paragraph 71, which reads as follows, I quote, "In sum, the Public Protector's powers to take appropriate remedial action is wide, but certainly not unfettered. Moreover, the remedial action is always open to judicial scrutiny." Close quotation. It is also not inflexible in its application, but situational And at paragraph 74, the court emphasizing the fact that decisions, although binding, are not immune from judicial scrutiny, said the following, I quote, "This is so because our constitutional order hinges also on the rule of law. No decision provided in the Constitution or law may be disregarded without recourse to a court of law. To do so would amount to a license to self-help." In the review application as well, in his answering affidavit to the application to compel compliance, the President has raised pertinent and crucial constitutional issues which can be summarized as follows. 1. That the remedial action directing the President to appoint a commission of inquiry is dictatorial and offends a separation of powers doctrine which is part of our rule of law. 2. That Section 84(2)(f) of the Constitution grants exclusive and executive powers to the President and no one else to appoint commissions of inquiry. 3. That no arm of government can constitutionally intrude into the sphere of the other unless authorized by the Constitution. 4. That the remedial action is inconsistent with the Constitution and accordingly invalid. In the matter of City of Tshwane Metropolitan Municipality versus AfriForum and another, AfriForum had obtained an interdict preventing the City of Tshwane from replacing the old street names in Tshwane with new names. That interdict was granted pending the review application brought by AfriForum to review the city's decision. The City of Tshwane held the view that the interim interdict should not prevent it from carrying out its decision and thus filed an appeal against the granting of the interim interdict. The full court of this division dismissed the appeal, so did the Supreme Court of Appeal. The city then petitioned the Constitutional Court for direct access to appeal the decision of the High Court. That matter was finally decided on the basis that AfriForum had not satisfied the requirements for an interim interdict to be granted in their favor. Hence, the appeal was upheld and Tshwane was permitted to continue the name changes notwithstanding the pending review application. There is a distinction between the issues and the facts in the City of Tshwane versus AfriForum matter and what is in issue in the present matter. It must be recalled that in the City of Tshwane versus AfriForum matter, AfriForum issued its first interdict when the city suspended, and when the city suspended the idea of the name changes, AfriForum did not launch a review application. It was only after 7 months, when nothing was happening, that when the city recommenced with the name changes, that AfriForum then filed a fresh interdict. In dealing with the aspect of AfriForum, having failed to prove that it will suffer irreparable harm if the interdict was not granted, the Constitutional Court held that irreparable harm implied that the effect of the harm could not be reversed. The Constitutional Court found that the review court could reinstate the old names if AfriForum was successful. The irreparable harm referred to in the AfriForum matter cannot, in my view, be compared to the irreparable harm that will follow should I conclude that the remedial action should be implemented, notwithstanding the pending review application. It must be kept in mind that at all times that what the President is asking for in the review application is that remedial action 8.4 be set aside on the basis that it is unconstitutional, it is dictatorial, and usurps the powers that vest in the President only. That application strikes at the very heart of the powers of the public protector and the extent to which a remedial action is authorized and circumscribed by the Constitution. It is significant to note that the public protector is not opposing the review application, but has filed an application opposing the application to stay the implementation application. The public protector, in her affidavit opposing the stay, says no more than that the President, as well as other ANC leaders, have at various platforms indicated that he is not opposed to setting up a commission of inquiry, but not on the terms as dictated to by the public protector. When the Constitutional Court refused to hear the DA's application during February 2017, it was aware that a review application had been launched. It is therefore not surprising that the Constitutional Court said that it was not in the interest of justice to hear the matter at that stage. In my view, the Constitutional Court implied that the review application must be dealt with and finalized before the President could be compelled to comply with the remedial action set out in 8.4. The public protector considered at paragraph 5 of her answering affidavit, the public protector considered at paragraph 5 of her answering affidavit to the stay application and said that this court has a discretion to stay the remedial action pending the determination of review if this court is satisfied that it is in the interest of the court to do so. In my view, it will not be in the interest of justice to direct the President to implement the remedial action prior to the review court having finalized the constitutional dispute raised by the President. I say that it will not be in the interest of justice because once the President appoints such a commission of inquiry, or even before he does so, he will be entitled to challenge the decision compelling him to do the appointment. This will result in parallel procedures based on the same issues, namely the review and the appeal against my decision. In my view, it will not only be a waste of resources, but may very well amount to abuse of legal process. Secondly, I inquired from applicant's counsel that what will happen to the Commission if the review court sets aside the impugned remedial action. I did not get a clear answer, save to say that it will stop to function. I'm not told what will happen to the decisions that the Commission may have already taken. The Commission may have incurred expenses in setting up offices, issued subpoenas to witnesses, and called for written submissions. In my view, it will not be in the interest of justice at this stage to compel the President to implement the remedial action. In the recent unreported matter between South African Reserve Bank versus Public Protector and 5 others, case number 43769/17, a judgment by my brother Murphy, dated the 15th of August 2017, the court had to deal with the challenge by the Reserve Bank against the remedial action taken by the Public Protector. At paragraph 9 of that judgment, the court said the following, I quote, "Despite initially opposing the application, the Public Protector filed an answering affidavit in which she considered the merits and consented to all the relief sought. She has agreed that her remedial action is unlawful in that only Parliament has the power to amend the Constitution and that she has no power to dictate to Parliament." Close quotation. The question to be asked is if that is what she said recently about Parliament, will her view be different when it is the President who claims the sole constitutional authority to appoint a commission of inquiry? That question will have to be answered on the 23rd of October 2017 in this court. The applicant has failed to demonstrate what prejudice or harm will befall it if the President does not appoint a commission of inquiry now, 10 months after the report by the Public Protector. Nothing has happened in the last 10 months. It will therefore not make any difference if the commission is appointed after the review shall have been heard, should the President fail in his application to set aside the remedial action. In the matter of the MEC for Health, Eastern Cape and another versus Careland Investments, the court held that when an administrator errs, those decisions exist and have legal effect until set aside on review. The review application raises important legal and constitutional issues and is a matter of great public interest on which this court still has to pronounce itself, and accordingly, to compel the President at this stage will not only be tantamount to denying him a hearing or his day in court, but it may also be understood to mean that the Public Protector's powers are unassailable irrespective of the content of a decision. That cannot be correct. In my view, it is immaterial whether the review application suffices to stay the applicant's application to compel or whether an order shall be granted as per the conditional counter application. The result will be the same. The applicant is being technical by insisting that the application to stay should have preceded the application to review. Interlocutory applications can be brought at any time during the proceedings. In summarizing the opposition to the granting of the conditional counter application, the DA considered that the standard for a stay application is the same as the standard for an interim interdict and rely on the decision of City of Tshwane versus Forum, also on the decision of International Trade Administration Commission versus SCORE South Africa, PTY Limited 2010, and lastly on the decision of National Treasury and others versus Opposition to Urban Tolling Alliance, and others. In the outer matter, National Treasury and others versus outer, the then Deputy Chief Justice Musena, in granting National Treasury leave to appeal the decision of the High Court, made the following remarks at paragraph 22. I quote, I am of the view that the pending judicial review raised at least two constitutional issues. The review has been brought under Section 6 of the Promotion of Administration Justice Act number 3 of 2000, a statute enacted to give effect to the right to just administrative action guaranteed by the Constitution. Secondly, the review poses the question whether the relief sought entails an improper trespass on the exclusive domain of the executive. Similarly, in the appeal before us, the prominent issue is whether the grant of an interim interdict has impermissibly trenched upon the constitutional tenet of separation of powers. These are constitutional issues of considerable importance. Close quotation. I've kept in mind that in deciding this application, it would be inappropriate for this court to express a view or usurp the functions of the review court. What is of prime importance is the considerable constitutional issues that have been raised, one of which is the aspect of separation of powers. The Constitutional Court in the outer matter, in upholding the appeal, expressed itself strongly on this issue. Lastly, in a unanimous decision of the Constitutional Court in the matter of International Trade Administration Commission versus SCORE, it was held that since the interdict had the effect of curtailing executive power to formulate and implement trade policy, and also caused irreparable harm by maintaining anti-dumping duties which would have otherwise ended, leave to appeal had been granted. The court strongly discouraged judicial intrusion on executive domain. In the present matter, the President makes the point that the Public Protector, in taking remedial action 8.4, is intruding on his executive domain. In my view, it will be in the best interest of justice to grant the President a stay of the implementation of the remedial action pending a decision of the review application. In any event, the Democratic Alliance itself makes the point that only a court order will suffice to suspend the implementation of the action. In the result, I make the following order. 1. The application by the Democratic Alliance, in which it seeks implementation of the remedial action 8.4 taken by the Public Protector, is hereby stayed pending finalization of the review application under case number 9.1139.16. 2. The applicant, the Democratic Alliance, and the second respondent, Public Protector, are ordered to pay the cost of this application, which shall include the cost of true counsel. I hand down the judgment.
Yours?
The one with from the
Unless
Can you say what?